Hello, everyone. My name is Jamie Jorgensen. I'm Senior Counsel in Husch Blackwell's Higher Education Group. I am in the Denver office. Before we begin, I would like to cover a few housekeeping items. At the bottom of your audience console, there should be multiple application icons for your use during the program today. If you have any questions during the webcast, please submit those via the question box. We'll try to answer all questions during the webcast today, but if a fuller answer is needed or we run out of time, we'll do our best to answer those later via email. A PDF of the presentation is available in the Program Materials folder. This program has been approved for legal education hours, so for live attendees, report your hours by clicking on the CEU icon at the bottom of the screen. A certificate of attendance, including the course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. For the end of the program, be sure to complete our short survey. We really do value your feedback, and we use that information to plan future programming that best suits your business needs. That's all for the housekeeping items, so let's get started with our program. We're going to talk today about search and seizure issues on campus. I'm joined by Claire Hawley, who is an associate in our Kansas City office. Claire and I agree that this is a really interesting area of the law. Most of us don't deal with these questions on a daily basis. But when the phone rings, our clients need quick responses. So we hope that this presentation will be a great refresher for you. I want to introduce Claire, and I can share that after her undergraduate years, Claire earned a grant to work with the Illinois Network of Charter Schools and worked with the legal team there. Her early successes in that position opened her eyes to the power of the law to make real change happen for people. In law school, then, Claire found herself drawn to the research and writing involved in the practice of law. Today, she views every legal challenge for her clients in higher education as a complex puzzle to be solved. Claire, welcome, and you can take it away.
Hi, everyone. So we're going to start with our agenda for today. We're going to begin with some key legal principles and considerations. Then we're going to move on to probable cause and search warrant exceptions, and then address some workplace privacy considerations for employees, as well as some student privacy considerations in campus housing and grounds. So to begin with the key legal principles and considerations, let's start at the beginning with what is the Fourth Amendment. So the Fourth Amendment protects individuals from government intrusions onto their property or of their persons. It does not ban all warrantless searches, only unreasonable searches. It reads, no warrant shall issue, but upon probable cause, supported by oath or affirmation, particularly describing the place to be searched and the persons or things to be seized. Warrantless searches are presumed to be unreasonable unless an exception applies. The main exceptions include consent, emergency, and plain view. These are the exceptions that we'll talk about today. There are others, but they are more law enforcement specific. Prohibitions against unreasonable search and seizure are also embodied in state constitutions. This is an example from Colorado. And as you can see, it has very similar language to the federal Fourth Amendment. So some key concepts for the Fourth Amendment. Searches and property seizures must be reasonable. Warrants must be supported by probable cause. And warrants must describe the place to be searched and the property to be seized with some particularity. And then there's the reasonable expectation of privacy. This is a concept established by Katz v. United States, a 1967 Supreme Court case. In that case, the FBI placed a recording device on a telephone booth without a warrant to gather evidence of illegal gambling activity and intercepted the suspect's phone conversations. The Supreme Court held that this violated the Fourth Amendment. This case is highly significant because it introduces the reasonable expectation of privacy concept in Justice Harlan's concurrence. So the reasonable expectation of privacy is a subjective expectation of privacy on behalf of the individual that society recognizes as reasonable. If a reasonable expectation of privacy exists and the government violates it, the Fourth Amendment has been violated. Other key principles from Katz include that the Fourth Amendment protects people, not things, and a showing of a physical trespass is not required to establish a violation, and a search warrant is a constitutional prerequisite, even if the government's action had probable cause. So consequences of Fourth Amendment violations. The first consequence is that the suppression of evidence obtained in the course of the illegal search. This is known as the exclusionary rule, and it was established in a 1914 Supreme Court case called Weeks v. United States. It is grounded in a concept known as the fruit of the poisonous tree. Once a court has determined that an arrest, which is a Fourth Amendment seizure, or a search violates the Fourth Amendment, all of the evidence that is gathered thereafter is the fruit of the poisonous tree and subject to exclusion from later prosecution. The second consequence of a Fourth Amendment violation is potential damages against the offenders. These would be brought under 42 U.S.C. 1983. 1983 claims vindicate a deprivation of constitutional rights under color of state law. Personal liability is murky. It depends on the clarity of the right that was violated. And then the Fourth Amendment application to state action. The Fourth Amendment applies to all state action, meaning actions taken by public institutions. It is applied to state and local governments through the Due Process Clause of the 14th Amendment. It extends to all operations of public institutions, not just the actions of law enforcement personnel. Private institutions regularly incorporate some Fourth Amendment protections by policy. Now I'm going to pass it to Jamie to talk a little bit more about probable cause and search warrant exceptions.
Thank you, Claire. This is, as I said, a very interesting area of the law, and while the Fourth Amendment sets sort of the touchstone of search and seizure law as reasonableness, we'll talk a little bit about the search warrant requirement that must be supported by probable cause, and then we'll get into some of the exceptions. So let's start with probable cause. Recall the text of the Fourth Amendment where the Constitution says that no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So probable cause to support a search warrant then exists when there is a reasonable probability that there is evidence of a crime in the place to be searched. That is a fluid standard. There is a little bit of I know it when I see it element to this analysis, and the courts are going to consider all of the facts and circumstances here, including the seriousness of the suspected crime. So next slide then. What is probable cause? Probable cause should be based on observed or observable facts and not supported by belief or hearsay. Typically, those are a search warrant is established by an affidavit from a witness, and the sources of the information that go into that probable cause affidavit. The best evidence is direct observation of the facts and circumstances by the affiant, or information shared by a first-hand observer, such as a crime victim or a witness. A couple of examples here to contrast the probable cause standard. The first example is one that's very general, where the affiant says, I've been told there are illegal drugs in the dorm room. Contrast that with the second example where the affiant says a resident assistant smelled marijuana from just outside the room, observed a pipe on the desk when the resident opened the door. The second example is far more specific, based on a first-hand observation, the affiant's own sensory perception of the sight and the smell of the marijuana and the related marijuana pipe. So a couple of examples of exceptions. Now the Supreme Court over many years have developed a number of different exceptions to the warrant requirement. And one of those that comes up frequently is the plain view incident to lawful entry exception. The plain view doctrine provides that no warrant is required if the state can demonstrate the following three circumstances, and we have to meet all three requirements here. The first one is, was there a valid intrusion into the location where the evidence is located? I.e., was the state actor here, did they have a right to be in the room, the house, the car, wherever the incident has taken place? Second, the item has to be in plain view. You can't start throwing open drawers, looking in closets and so forth. The item has to be basically laid out where anybody can see it without having to search for it. And finally, the incriminating nature of the item must be immediately apparent. We're not allowed to use post hoc justifications to determine whether the evidence that is in plain view really is an indicator of criminal activity. Let's take a look at a scenario here and talk about whether this is a good example of a plain view exception. This case is goes back to 1982. It's a Supreme Court case. A student is stopped for underage possession of alcohol on campus. The student says, I want to go get my ID from my dorm room, and so he's accompanied by campus police across the campus to his room where he looks for his ID. The officer accompanies the student to the room, sees marijuana seeds on the desk, as well as a pipe, seizes the evidence, and charges the student. There's no search warrant here, but the court holds that this is an application of the plain view exception. This is Washington against Chrisman. The officers were entitled to be in the room by virtue of the student's consent, and therefore they were free to seize that evidence that was laying right on the desk. You might think of a number of variations on this hypothetical, including if the student said, well, why don't you wait outside, officer? I'll be right back. And in that case, if the officer does not have permission to go in the room, they are not allowed to step into the room. They might see the evidence on the desk through the doorway. That would be an acceptable plain view application. But the facts here really matter, and we're going to see that in a number of other scenarios here. A couple of other warrant exceptions that we don't have slides for. One is exigent circumstances. This goes back to 1978, a case called Mincy against Arizona. There are circumstances where a warrant is just not reasonable for the police to obtain it because there is a concern that, if they wait and go seek a warrant from a magistrate, somebody could get hurt, for example, whether that's an officer or another member of the public. Evidence might be destroyed, the suspect might escape, or there's some other potential consequence that would frustrate a legitimate law enforcement purpose. Another example of a search warrant exception would be what's called search incident to a lawful arrest. If the police make an arrest of a suspect, they are allowed to search that person, their clothing and their body, as well as the area within the person's immediate control. And that is an exception that there is quite a bit of case law on what constitutes immediate control. I'm having a flashback to my law school criminal procedure class with Professor Yale Camisar, who passed away recently. Professor Camisar had let's say, a healthy distrust of law enforcement, and when discussing the question of immediate control, he would lament that the police officers would argue that the suspects I think he said something like they all turned into Jesse Owens and they can jump 20 feet, which justified an expansive immediate control area search. Funny the things you remember, but those are just a couple of additional examples of exceptions to the warrant requirement. Let's talk a little bit about consent. Consent is, I think, by far the most commonly invoked exception to the warrant requirement on our campuses. And Claire will talk about this in some detail, but the notion is that we regularly obtain consent by developing and distributing policies that define the circumstances of our campus searches. So individuals are allowed to waive their rights, their Fourth Amendment protections. That is a common occurrence. We have to make sure that the consent to a search is voluntary. So especially in the law enforcement context, you'll see courts reviewing the totality of the circumstances to make sure that consent was not coerced. And just a note here that police are not required to inform individuals of their rights to refuse a search. That's different from Miranda rights, which we're so familiar with from our TV dramas. Miranda relates to the rights to refrain from saying anything that could be self-incriminating. So in terms of questioning of a suspect, Miranda rights may well apply. However, police are not expected to provide individuals with notification that they can refuse a search. Okay. Claire, you want to talk a little bit about workplace searches?
Yep. Okay. Let's talk about the privacy considerations implicated by workplace searches and monitoring. Generally, public sector employees have some expectation of workplace privacy, particularly in their personal effects. So O'Connor v. Ortega is the leading case on workplace searches. To determine whether the search violates the Fourth Amendment, first you must determine whether there is a legitimate expectation of privacy based on the operating realities of the workplace, such as past practice or policy. Even if there is a reasonable expectation of privacy, a search may proceed if it is for a legitimate business purpose and the scope is reasonably tailored to that purpose. And so, some practical considerations for emails and electronic data policies. Key inquiry here is whether the employer notified the employee that they cannot reasonably expect that their internet activity or emails will be private. If so, searches of employee computers, emails, and browsing history are reasonable. This notification is presumed if the employee has a published policy, even better if the policy is formally acknowledged by the employee. The best practices here would be to have a written policy on the acceptable use of workplace and technology computers that clearly states that use is not private and may be monitored. Employees should be required to acknowledge the policy, potentially by signing a written copy of it or electronically agreeing to its terms. Some more practical considerations. Consider how state public record laws impact privacy expectations. We'll discuss these shortly. Consider the institutional policy language. What do you say about access to files by administration? Do you allow occasional personal use? Are there practices that form privacy expectations? What are your password practices? Do you use a shared drive versus local drive for storage? And then there's business use on personal devices. Computer ownership is not always dispositive. Courts have sometimes ruled that an employee enjoys Fourth Amendment protection in an employer-owned device, and on the other hand, have found no Fourth Amendment protection in a personally owned device. It is a case-by-case, fact-intensive inquiry. Now some practical considerations for electronic communications, specifically applicable state and federal laws. So for the real-time monitoring of phone or email, eavesdropping laws prohibit the use of electronic devices to listen in on private conversations. Be careful to consider single versus two-party consent states for recording a telephone communication. And then the Federal Electronic Communications Privacy Act prohibits unauthorized interception of oral, wire, and electronic communications. This is different from accessing electronically stored communications. And then exceptions to the FECPA are employer-provided service and consent, which can be implied when there's a published policy. So, scenario 1, employee smartphones. An employee has a college-issued cell phone. The college has a policy, which the employee read and signed prior to getting his phone, reserving the right to monitor and log all network activity without notice to employees. The employee exceeded his monthly text message allowance multiple times, and his supervisor requested transcripts of the messages to determine whether the overages were occurring as a result of the employee's personal use of the phone or proper work-related use. The resulting search revealed personal messages to the employee's wife and alleged mistress. So we have a poll here. So what do you think? Do you think this is a lawful search of the employee's phone? Give everybody just a few minutes to answer, a few seconds. All right, we have about 200, a little over 200 responses submitted. So I'm going to go ahead and go to the next slide. So the majority of you were correct. This is a lawful search. This is based on a Supreme Court case from 2010, City of Ontario v. Kwan. And the court ruled this was reasonable because it was limited in scope. The employer's policy stated, users should have no expectation of privacy or confidentiality when using these resources. The court did not address the question of the employee's reasonable expectation of privacy in the data of his phone because the search was legitimate or reasonable. So scenario 2, a professor was provided with a university computer. The university has a policy reserving the right to view or scan any file stored on the computer and will do so periodically to audit the use of university resources. The professor used his computer to download over 3,000 pornographic images of young children. The state police conducted a warrantless search for child pornography on the professor's university computer and found the files. The professor was subsequently arrested. So now we have a second poll. So let me know what you think. Was this a lawful search of the employee's computer? We have about 50% of people submitting, and the majority of people were right. This is a lawful search. This is based on a 2002 case from the 10th Circuit, U.S. v. Angevine. The court found the search lawful. University policy prevented employees from reasonably expecting privacy and data downloaded onto university computers. The police didn't need a search warrant because the professor didn't have a reasonable expectation of privacy in the seized computer. Okay, so now let's go into some practical considerations for video surveillance. Video surveillance is generally allowed, subject to legitimate privacy expectations. There's no general expectation of privacy when in public view, including in the workplace. General surveillance is allowed. Targeted surveillance is potentially troublesome. For example, the NLRA prohibits surveillance of employees engaged in protected concerted activity. The best practice is to develop a policy on the deployment of cameras and video footage access and retention practices. Another example would be signage saying this area is under video surveillance. Searches of employee desks, offices, and lockers. Employees have limited case-specific privacy rights in desks, offices, and lockers that are shaped by policy. The constitutionality of searches of these items is judged by the standard of reasonableness under the totality of the circumstances. Courts have generally held that searches of property that the employer provides for employee use do not violate the Fourth Amendment. Common reasons include employers regularly search such offices. Those items in space are often shared by employees, and/or the search has a work-related purpose. So searches of employee desks, offices, and lockers following disciplinary termination. In Shaw v. Cherry Valley, Springfield Central School District, a teacher was suspended for suspected sexual assault of a student. School employees removed his personal belongings from his classroom in a locked cabinet to prepare it for another teacher. The Second Circuit held that the search of the teacher's classroom and locked cabinet was reasonable. The teacher surrendered any reasonable expectation of privacy he may have had in his classroom once he was asked to surrender his school keys and given 2 opportunities to remove any personal belongings. As a general rule, employer invasion of employee privacy is reasonable at its inception if there are reasonable grounds for suspecting that the search will turn up evidence that the employee is guilty of work-related misconduct or that the search is necessary for a non-investigatory work-related purpose, such as to retrieve a needed file. And then if employees have a shared office, they generally have no reasonable expectation of privacy in that office or the content. In People v. Powell, the court ruled that a paid graduate student did not have a reasonable expectation of privacy in their combination office and laboratory, which is also assigned to a professor and a university employee. When the employee, professor, and others had access, and the grad student didn't have the key to the office or the ability to exclude others. Employee cars. The reasonableness of employer searches of employee vehicles is a case-by-case determination. When parked on public employers' property, employee cars are generally considered part of the workplace and subject to the same Fourth Amendment analysis as offices, desks, and devices. Key factors considered by the court include whether the employees were on notice of potential searches via signage, written policy, or past practice, how often such searches were conducted, if they're random and sporadic, that weighs against reasonableness, and if they're consistent and indiscriminate, they look more reasonable. The interest and reason for the search, so for example, security concerns justify searches of employees upon entry to airports and prisons, and finally, whether the employer had reasonable suspicion for the search. So for example, specific information or an observation suggesting illicit or dangerous items we found in the employee's car. And then a final point, a question that's commonly asked is whether employers can lawfully use GPS to track their employees. They may want to do this for many reasons. Supervision of routine job duties, such as tracking the delivery of a package or monitoring a route, liability purposes for situations where the employee gets into a car accident while on duty, and investigation of alleged misconduct. So, is this legal? This area of the law is relatively new, so the answers to these questions are not cut and dry. Only a handful of courts have addressed whether employers can legally use GPS to investigate suspected employee misconduct. In the few rulings that have been issued, the critical factor is whether the GPS device was installed on a company-owned vehicle or a personal vehicle. If on a company-owned vehicle, it tends to be viewed as more reasonable. Courts also look at the information gathered from the GPS. So for example, if the GPS only revealed information about the whereabouts of the vehicle while the employee was at work, that it tends to be more reasonable. But if the GPS reveals data about the vehicle 24 hours a day, 7 days a week, especially when the employee is on personal time, it's viewed as less reasonable. Employee drug testing. So there are 3 types of employee drug testing that often raise Fourth Amendment issues. The first is random suspicionless testing. The Supreme Court has established a balancing test for this kind of drug testing. First, courts consider the employee's privacy interests to determine their reasonable expectation of privacy in light of the character of the employer intrusion. Then, courts consider the employer's interests, specifically the nature of the interest to be furthered by drug testing, the immediacy of the employer's concerns, so the employer must demonstrate an immediate threat to its interests, and the efficacy of the testing policy in addressing those concerns, meaning the employer interests couldn't be addressed versus a suspicion-based approach. Finally, those 2 interests are balanced to determine whether it is impractical to require some level of individualized suspicion prior to requiring a drug test. So factors commonly considered by the courts in relation to random suspicionless testing include the nature of the employee's position, specifically whether the successful performance of assigned duties reasonably depends on abstinence from substance use, whether the employee's duties implicate public safety or national security. So random drug testing has been approved for employees who maintain and operate trains, airplanes, and automobiles, carry firearms, have access to illicit substances such as DEA agents, or have access to children. Another factor considered is whether the employee is on notice of the testing. And finally, whether the employee's privacy interests are subject to other similar intrusions, such as stringent background checks. Outside of random testing, public employers may drug test specific employees if they have a reasonable individual suspicion that the employee is using drugs or alcohol. This suspicion must be based on specific, objective, and articulated facts and reasonable inferences drawn from those facts in light of experience, including direct observation of drug use or physical symptoms of substance use, abnormal conduct or erratic behavior such as missing work or declining work performance, a report of drug use from reliable and credible sources, evidence that an employee has tampered with a drug test, or when an employee has caused or contributed to an accident at work. A word of caution, though, if the employer requires the drug test for discriminatory or arbitrary reasons, such as without reasonable suspicion or on the basis of protected characteristics like race, age, or disability, the employer may be liable for wrongful discharge. When an employee refuses to submit to testing, the courts have generally held that as long as the request for testing is lawful, that the employee can be subject to sanctions for the refusal, especially if the testing policy has been adequately communicated in advance. Sanctions may include discipline, termination, and denial of unemployment or workers' compensation benefits. And then finally, pre-employment screening or drug testing of job applicants. In 2018, the 11th Circuit held that a public school district's suspicionless drug testing of applicants for substitute teacher positions did not violate the Fourth Amendment. The district had a special interest in ensuring that substitute teachers were not impaired as they oversaw the safety and education of students. Drug testing was also minimally invasive. The urine collection occurred in a private bathroom and the test results were confidential. Finally, sometimes testing is required, such as by the Department of Transportation's legally mandated drug and alcohol testing for safety-sensitive transportation employees, such as semi-truck drivers. And finally, avoiding privacy tort claims. So in addition to Fourth Amendment violations, employee searches may give rise to common law liability. 3 such examples are intrusion upon seclusion, which is intentional and highly offensive intrusion into a truly private affairs of another, causing mental anguish and suffering. The second is public disclosure of private facts, which are intentional public disclosure of truly private facts that are of no legitimate concern to the public. And finally, intentional infliction of emotional distress. Intentional or reckless behavior that is so outrageous or shocking that it causes severe emotional distress. Employers should focus on legitimate expectations of privacy shaped by policy and practice. And now I'm going to pass it back over to Jamie to talk about student privacy considerations on campus.
Thanks, Claire. There are a couple questions in the chat box here, and hopefully we can get back to most of these before we wrap up today. But a couple of the questions that were asked about the distinction between state employed or county employed or municipality employed police officers, law enforcement personnel versus private security, and whether that distinction matters. It does matter. Private security firms are generally not held to the standards of the Fourth Amendment unless there is some delegation of authority by the state to that private security force. And in some cases that can be done. There's a line of cases about private actors becoming agents of the state and the circumstances under which that might be true. and therefore, if they become an agent of the state, they may well be subject to Fourth Amendment limitations. So these are good questions. That public-private distinction is a very important one throughout here. So I just wanted to address that quickly before we move on to student privacy rights here at campus housing and grounds. Okay, let's talk first about student housing. Similar to the employee circumstances, students generally have a reasonable expectation of privacy in student housing. That is a pretty well recognized right in the law. Most student housing searches proceed under the consent exception to the warrant requirement. So if your residence life staff needs to access a student room, they do so based on consent. Where do we find that consent? Typically, in your student housing agreements, you will have language defining the circumstances in which housing staff can enter and search student rooms, or what are often referred to as institutional purpose searches. You might see language that talks about health and safety reasons for accessing a room. But I would guess that almost all of your student housing agreements have some kind of language to that effect in them, defining and setting forth the boundaries for access by your staff to those rooms. You might ask then why, let me put back quickly, you might ask whether, well, does that exception kind of swallow the rule? Can you write the exception or the language so broadly in your student housing agreements that gives you sort of carte blanche to enter a student's room at any time for any purpose? Public institutions, you should be very cautious about overdoing it. The courts have said that this kind of language should be, quote unquote, limited in scope and written with the mind that you are making this privacy exception in order to facilitate your achievement of legitimate institutional interests, health and safety things, again, accessing rooms to look for evidence of a policy violation, for example, drugs, alcohol, firearms, and things like that. But they should not be written to facilitate law enforcement purposes. There's a clear distinction between the college or university's interest in accessing a student room versus law enforcement access in order to gather evidence of criminal activity. So warrantless searches, you'll see this in the case law, warrantless searches for the purpose of discovering evidence to be used in criminal proceedings. The courts are far more skeptical about those circumstances and less likely to uphold the search. Okay, let's do a scenario here at student housing. This is a fun case from Massachusetts back in 1996. A student at a state school signs a residence hall contract which provides that, quote, residence life staff members will enter student rooms to inspect for hazards to health or safety. Standard language. A maintenance worker then hears a cat inside the dormitory suite containing 4 bedrooms. This is before the days of emotional support animals. Cats are not allowed. College officials post notices on all of the bedroom doors in the suite informing the students of a door-to-door check coming up that will at 10 o'clock that night due to possible violations of the college policy. So the students are put on notice. Officials from the college entered the student's bedroom at 10 p.m. when the student was not present. They notice a light on in the closet, and concerned about a fire hazard, they open the closet door to find, surprise, 2 large marijuana plants. The officials then notify campus police. The police enter the student's room, they take pictures of the evidence, and then they seize it, removing all the evidence in the room, and they have no warrant. So, what does the court do with this circumstance? This is Commonwealth against Nielsen. If you know this case, you're going to be able to answer this poll question easily. Was this a lawful search of the student's room by law enforcement? Not by the college residence life staff, but by law enforcement. A, yes. B, no. C, no, unless the cat gave consent to the search. Let's take a vote. All right, the votes are trickling in here. Give you a couple more seconds. Okay, let's close the poll and see the results. We have just about 50% say yes, about 45% say no, and then we have a handful of people who are looking to the CAT for guidance here. If you said no, you are of like mind with the Massachusetts Supreme Court. The court held there that the search was not authorized under the Fourth Amendment. First, if you recall the previous slide, there is discussion about whether the search was undertaken for law enforcement purposes versus the institutional purposes of the college. And by the time the police are there without a warrant, the court says that none of our exceptions apply. There are no exigent circumstances occasioned by the housing staff's initial search. The marijuana is not going to get up and walk away. The students are not there to take it out of the dorm room and throw it. There's no cat, which was the initial reason for the search. There's no fire hazard. So there is no real legitimate reason for the initial search by law enforcement. And the housing agreement says that the search consent did not authorize searches for the purpose of finding and confiscating evidence of a crime. So that the housing contract does not contemplate law enforcement searches as part of their consent language. The plain view doctrine doesn't apply here. Why? Because the officers were not lawfully present in the room in the first place. That's a prerequisite to the application of that plain view search warrant exception. Okay, let's do another scenario here, involving student housing. This case involves a state university police officers responding to a burglary reported to have occurred on the third floor of Random Hall, the residence hall. Although the lobby to the residence hall building is accessible by the public, you need a key card to get into the hallways of the individual floors where the student dorm rooms are located. So the officer starts to walk up and down the halls, ending up on the first floor at student A's dorm room, or through the door, the officer hears students say, "I'm just paranoid we're going to get caught." A footnote here, the officer is able to access those halls because resident staff have provided officers with key card access, okay? So the officer overhears the student, the officer knocks, identifies himself, and then orders student A to open the door. Student A complies, the officer enters the room, immediately sees 3 smartphones, several pieces of jewelry on the desks, and arrests student A for burglary. Okay, is this a lawful search here? The university housing has key cards, again, by virtue of being given them by the residence life staff. Does that allow them access to the room? And the court holds no. This is State against Haufner. It's a Washington State Court of Appeals case from 2008. This is a really interesting case here. The court applies a 2-part test to determine whether there's a legitimate expectation of privacy in the common areas, the hallways here, where the officer is present and hears the student through the door expressing concern about getting caught for the burglary. The court applies a 2-part test to determine this expectation of privacy. The expectation has to be subjectively held and objectively reasonable as well. To determine the subjective part, the court says, yes, there is limited access to the common areas of the floor, and the students moving to and from the showers in partial states of undress. All of those things make it perfectly reasonable for a person to hold the belief, a resident of that hall, to hold the belief that there's some privacy expectation in the common areas, okay? And then the court evaluates the objective standard here, and again, it's a very detailed, fact-specific inquiry. And the court likens the hallways to what is referred to as the curtilage of a home. So the outer areas, your front porch, your sidewalk. That's not a word I get to use very often, so it's kind of fun, curtilage. And the court likens the common areas to that area of a home as opposed to the common hallways in an apartment building. And again, the court really looks to the key card access fact here as indicating that there is an expectation of privacy in the hallway. So once the court reaches the conclusion that there's a reasonable expectation of privacy, they also note that the student didn't waive that right to privacy. There's no consent here, and therefore the law enforcement officer did not have the right to be in the hallway absent a search warrant. So what follows from that? Well, the law enforcement officer's eavesdropping through the door constitutes an unconstitutional search. Likewise, the law enforcement officer demanding access to the room constitutes an unconstitutional search. And then the evidence seized thereafter in the dorm room was the fruit of the poisonous tree and not admissible. Again, I want to point out this case really points up the fact-intensive nature of these analyses. It's an interesting opinion. The court compares and contrasts the details of the living circumstances in various fraternity houses versus apartment complexes versus this residence hall floor, and determines that there's a reasonable expectation of privacy. They look at the key card access, they look at the shared showers and restrooms, and they also look at the rules, how the rules are established in this residence hall. It's akin to kind of a living, learning community in modern times, where the residence hall, the residents themselves, the students, are given some authority to author their own rules. So there's some self-governance factors there about access to the place and how the space is used. All of those things go into the analysis by the court. I think it is hard in the moment when the phone rings, or you're the residence life staff person or the law enforcement officer. It's hard to force yourself to slow down. There's time pressure. But I think it's important to take a breath and start asking questions about these kinds of details and thinking through these things before you decide whether it's appropriate to search a room in that circumstance. You're really well served to take a pause and dig into the specific circumstances before you make a snap decision. Okay, let's do another scenario here. Scenario 3, which is a campus ground scenario. Campus safety gets a phone call from an instructor who says a student has come to the class and they smell like weed. By the time the campus safety officer arrives at the classroom, the instructor has searched the student's book bag and found marijuana. The student yells out that he did not consent to the search and demands to speak with a lawyer. What do you do? Well, this case is from 1985. It's a United States Supreme Court case called New Jersey against TLO. It's a K through 12 case, so we use the initials of the student here rather than identifying them. But this is a case where the court held that the search was not illegal, based on and they apply a reasonable suspicion circumstance that's lower than probable cause, the probable cause standard that supports a search warrant. Note here that the search is conducted by the instructor, not a law enforcement officer. Okay. That is a very important factor. And the court holds that in those circumstances, they will balance the privacy interests of the individual student against the institutional needs to maintain an orderly educational environment. The court then concludes that there is no warrant required, and they look at two basic factors here. Was the search reasonable at its inception? And in this case, the court holds that yes, there had been a report of smoking earlier that was in violation of the college policy, and that justified a search of the bag. Once the instructor searches the bag, they discover rolling papers, and then that creates a reasonable suspicion of marijuana possession that justifies a further search where that evidence, the drugs, are discovered then. The court then looks at a second factor. Was the search excessive in its scope? And again, the court reviews the facts and says, no, it was not excessive given what was known by the instructor at the time. Okay, let's talk a little bit about vehicles. I saw a question in the chat about this, so hopefully we can address that. Vehicles are considered a little bit different than, say, a residence hall room. Now, historically, there are some privacy rights within one's vehicle, but they're reduced. Okay. Law enforcement officers generally need at least reasonable suspicion to stop a vehicle, and then before they search it, they have to meet that higher standard of probable cause. And probable cause meaning probable cause to believe that there's contraband in the vehicle. There's some material there that will be related to or serve as evidence of a crime. Now, often in these cases, a warrant is not required because the court recognizes the practical fact that vehicles can drive away. And so we apply an exigent circumstances analysis here to decide whether the officer was required to get a warrant. Courts have held, there's a case from 1996, the Supreme Court recognizes that the vehicle's mobility constitutes an exigency that's sufficient to excuse the failure to obtain a warrant by the police officer, but only once they've established probable cause for the search. Okay, now as to the driver and the passengers, there are, if you're familiar with stop and frisk rules, that is allowed. A police officer is generally allowed to pat down a driver or a passenger in the circumstances of a lawful stop there. And then finally, the exceptions that we discussed earlier in the presentation, search incident to lawful arrest, and then the plain view doctrine also apply to vehicle searches. So let's do a scenario here with a campus vehicle search. Campus police officer has reason to believe that a student's car parked on campus contains illegal drugs in the trunk. Note that the car has been parked in the same location for 3 weeks and there's a boot on the tire, preventing the student from moving the car because there are unpaid parking tickets. So the student has to pay those tickets before the boot will be removed by campus police. The campus police officer nevertheless uses a crowbar to pop open the trunk and finds 10 kilos of cocaine. So let's do a poll here. Did the officer conduct a lawful search of the vehicle? A, yes. B, no. C, I'm not sure, but I think I saw that car parked at the Snell Farm in Season 2 of Ozark. What do you say? Let's take it to a vote. Few more seconds here. Okay, let's close the poll and tally the votes. We have a significant majority saying no, this is not a lawful search. And in fact, you are in agreement with the court here in this case. An illegal search because the automobile exception to the warrant requirement does not apply. Why? Because the vehicle can't be moved. We've got the boot on the tire and it can't be driven away. Again, that vehicle exception, the exigent circumstances exception, only applies if there is a legitimate, reasonable concern about the vehicle disappearing before the officer has time to make the search. Okay, good. Let's take a look at student email now. We're wrapping up here and then we can get to some questions. Question about whether an institution can monitor and access student email accounts. Again, not unlike the workplace circumstances, institutions should form the expectation of privacy through their policy language. Please, can't emphasize this enough. Be careful and cautious and think through those circumstances that would allow you to search student emails, and also the circumstances where you're willing to keep your hands off those files. Give examples of what may constitute circumstances where the institution would go through an email account or monitor an email account on an ongoing basis, and give, as I said, give some circumstances here, such as during the course of an investigation of a policy violation. Or if you're a public school, it's good to warn people about the idea that public records laws may apply. Now, that's questionable, I think, in student email account cases. Certainly applies for employee email accounts. But there might also be cases where the email account is subpoenaed or the institution is subpoenaed for access to that email account. I think the more disclosure here and the more that you can elaborate to educate folks about where their privacy rights start and stop with respect to email, the better off you'll be. Okay, and then we're going to talk about student video surveillance. This is an interesting question. Claire and I have talked about this case. This is a K through 12 case, but I think the principles are similar here for higher education. When and in what circumstances can you engage in video surveillance of students? Again, I think it is not wholly unlike the workplace circumstance in that most people understand that when you go out in public, you may well be subject to video surveillance. In this case, however, Branham against Overton County School Board, the school instituted a video surveillance system that included, among other places on the school grounds, the locker room. And that may immediately raise some eyebrows for you. It did for me. And the court looks at the circumstances here. And before they really get into the analysis, though, I like this quote here where the court really gives a nod to video surveillance. They acknowledge the intrusive nature of video surveillance. It's just different. It's qualitatively different than personal observation by a member of the school community. It's so comprehensive, and the quote here, "A video camera sees all and forgets nothing," really illustrates that. I think that reflects the court's, a little bit of unease with video surveillance. However, I would also note that this case is now 14 years old, and a lot has changed since then in terms of the prevalence of this technology. There are cameras everywhere, and we are all have kind of gotten used to that. Cameras on our front doors and in our driveways and in our workplaces, in retail establishments. The cameras have become an inexpensive means of providing security. And so I think as time passes, we get more and more used to being watched, essentially. Okay, well, let's look at the two-prong analysis employed by the court in this case. First, the court examines whether the state action, in this case the installation of the cameras, was justified at its inception. And here the court finds that yes, that there was justification for the imposition of a video surveillance system. And the court says there are reasonable grounds for suspecting that the search will garner evidence that a student has violated a law or a rule of the school, or that there's some imminent danger of injury on school premises. So the court is okay in general with the use of video surveillance technology. However, the second prong, whether it is reasonable in scope. The search, was it actually conducted in a way that was reasonably related in scope to the circumstances which justified the surveillance in the first place, and not excessively intrusive in light of the age and sex of the student and the nature of the suspected infraction. And you can imagine that the locker room surveillance raised quite a few eyebrows with the court here in this case. The court holds then that search is not reasonable in scope and it was excessively intrusive. And there are a number of really complicating factors here for the school. The students and their parents were not informed about this. Obviously, the students are young. This is a middle school. The students are in various states of undress in the locker room. And there's some other facts from the case that just don't look good for the school here. The video footage was stored in an electronic or a digital format, and school administration never changed the password from the default password that came with the system. There was evidence that there were external people, third parties that accessed the video footage that was stored. When the video surveillance equipment was discovered by a visiting sports team in the locker room, they were told by the school that it was inoperative when in fact it was that the cameras were rolling and footage was being collected. So this is a host of facts that work against the school in this circumstance, and the court does indeed conclude that the imposition of the student video surveillance equipment was an unreasonable search. Okay, that is all we have for today. There's a few questions in the chat here, and I'll try to get to a couple of these. First question from Johnny: if you leave a tape recorder hidden in a public area to capture audio, is this a violation? And Claire talked a little bit about this in workplace monitoring. Claire, do you want to jump in here?
Yeah, so leaving a tape recorder hidden in a public area is essentially like a listening post, and so that would not be a violation. But again, signage and written policies are always best practice.
Yeah, I agree with that. There are a number of states that have laws, maybe most states have laws against eavesdropping. That's the use of an electronic device to intercept a conversation to which the listener is not a party, okay? And there's all kinds of technology now that can be used for this. I've seen circumstances where, a baby monitor was deployed in the workplace, and that is forbidden under a lot of state laws and may in fact be a criminal violation. So we're going to be very cautious about audio capture. Let's take a look at another case, or another question here from Laura. Double checking that there is no Fourth Amendment protection for personal devices that are also used for business. I would say I would think about it a little bit differently. What you're really looking at in terms of the Fourth Amendment is what is the state action? And can the state search a personal device that is used for business? Again, use your policy to shape up the expectation of privacy here for your employees. And you may well say that we realize that our employees are going to use personal devices to conduct business. We've all got our smartphones. We're all constantly checking our email, communicating by text. And you may say that, in fact, there might be circumstances where we do need to access your personal device to, for example, conduct an investigation or respond to a public records request. That I know that has come up from time to time, the question of whether by removing public business to private devices, private email accounts, does that circumvent public records requirements? And I think most courts would say, no, it does not. You can't make an end run around a public records law by using a Gmail account, for example. So I would be cautious about that and make sure that that is addressed in your policy. Let me see what else is in here. John writes, if the space is provided solely for the employee's personal use, can they have an expectation of privacy? For example, if employees are required to place personal items into a locker because they cannot be brought into the workplace for safety reasons. And again, as an employer, you can shape up the expectation of privacy here through your policy. So you may well say that we're going to provide locker storage space or some other kind of storage space like this where only the employee has access, but I think I would be cautious about overdoing it here. There may well be circumstances where you need to make a search in an emergency or some other case where you have reason to believe that somebody has violated a policy. For example, would you allow an employee to bring a firearm into the workplace even if they kept that in their personal locker? I can imagine many employers would look askance at that, and if they had a reasonable belief that that was stored in a private space, they may well want to search that. So, let me see what else here. We've got maybe time for one more question. Suzanne writes, can you explain items found after being left in a company vehicle that was driven and signed out by a certain employee? Well, I think Claire, you may want to weigh in on this one as well, but I think that if somebody inadvertently leaves some kind of incriminating evidence or materials in a company vehicle, they are subject to the application of any policy relating to that evidence, right? That if somebody leaves drugs or a weapon or something like that in a vehicle, I don't think you have an expectation of privacy in that circumstance, unless there's something that I'm missing with respect to your misplaced or mislaid items that you then walk away from. Claire, any thoughts on that?
Yeah, I would agree. I think leaving the item in the company vehicle would diminish the reasonable expectation of privacy significantly.
Yeah, especially a company car where you're only using it intermittently and there are other drivers coming and going in that circumstance. Okay, well, we're at the top of the hour, and we don't want to run over, so I've got a couple closing remarks here to read to you about CLE and so forth. Let me just remind everybody, the program's been approved for legal education hours. Please report your hours through the CEU icon at the bottom of the screen. Certificate attendance, we will send that to you with the course numbers. We'll send that by email tomorrow along with the recording of the webcast. And be sure to complete our survey. We do really use that feedback to plan our programming, so I hope you take a few minutes to complete the survey. And most importantly, thank you so much for joining us today. We hope this information was helpful to you and to your organization, and we look forward to hearing from you. Thank you.